to another episode of ACA Cast with your host this week, Alex Zito. ACA Cast is the official podcast of ACA International, the leading voice of the accounts receivable management industry. So TCPA is such a hot issue right now in the industry. In today's episode, we're going to highlight one of the most anticipated sessions taking place at ACA Fall Forum and Expo on November 6th to 8th in Chicago. Before we start today, the content presented today's episode is for general references only and should not be used as legal advice. ACA is always ahead of the curve on the constant changes in our industry. That's why we're proud to present a new education track focused on some of the most pressing issues of the receivable management industry is currently facing. Join us at ACA Fall Forum and Expo on November 6th to 8th in Chicago. For more information, go to our website. I appreciate you taking your time today joining us, and I have an insightful interview that I know you'll enjoy. Joining with me today is Leslie Bender, Chief Strategy Officer and General Counsel at BCA Financial Services.
Hello, everybody. My name is Leslie Bender, and I am a member of ACA's Members Attorney Program Committee, and this is the first committee-sponsored podcast, and today we are very fortunate to have industry experts who probably need no introduction here to talk to us today about some of the recent developments in the Telephone Consumer Protection Act case law. It is something that changes literally at least once a day. So these two are experts in the field, Daniel Delnero as well as Eric Troutman. If you enjoy this podcast, I encourage you to come to Fall Forum where you can hear Eric in person. So today what's unusual about this podcast is that a lot of the information about the TCPA or the Telephone Consumer Protection Act is not unique or customized to things that debt collectors or call center people might be doing. And today we've asked Daniel and Eric to focus on some of the case law in the past 12 months and what lessons we can learn from it as it might relate to the whole business of collecting debts, whether you are doing that in the first party, namely in the creditor's name, or third party. And a few weeks ago, Daniel, you wrote a very thought-provoking article about a $267 million TCPA judgment that was entered against a debt collector, and you provided some excellent practical advice. Do you want to talk a little bit about that decision and sort of how it caught your attention?
Sure. The decision was McMillian versus Rash Curtis and Associates, and it's a $267 million class-wide TCPA verdict against a debt collector. And this case really caught our attention and caused us to feature it on the TCPA World blog because it's very unusual for a debt collection TCPA case to get certified. Typically, individualized issues of consent and revocation trump and predominate over any form of common issues such as ATDS. Well, that wasn't the case here because the debt collector had a practice of calling skip trace phone numbers through its dialer, which really is a very dangerous practice. A skip trace number, almost by definition, is one in which the debt collector does not have consent. It's a number that they obtain through a third-party skip tracing service or by calling friends and family members, that sort of thing, to where it really isn't clear at the time of the call whether it actually belongs to the individual you're trying to reach. In that sense, it's very easy to certify a nationwide class because consent's a common issue. You were calling skip trace numbers which you previously had no relationship with. Also have the fallback common issue of whether the dialing technology was an ATDS. So the lesson in this case is frankly very simple. Unless you're calling a phone number at which you have consent, such as through previous right party contacts or where the individual has actually provided the number to you, either from an application or as a result of other contacts, do not call that individual through a dialer. Call them through a manual process. And it's also important not to call them through a manual process that invokes the same technology as your dialer. As we saw in other recent cases, we still have that lurking capacity issue, even after ACA International, to where if a manual mode of dialing is essentially through the same system, borrows the same functionality as a dialer, then you run the risk of having even your manual calls be deemed an ATDS call for purposes of the TCPA.
Interesting. Let's drill further into that since we have Eric, otherwise known as the czar of TCPA world. And TCPA world, by the way, this is not a commercial message, but anybody can sign up to read this blog. It drops into your inbox as frequently as cases seem to hit the landscape. And Eric, why after all this time are we still not clear on what an ATDS is? All these courts are ruling on this. Why don't we have clarity on that issue?
And can I just say, though, before we leave McMillian, that these guys were just asking for it. You know, just don't auto-dial skip trace numbers, right? It's just very basic stuff. Don't get cute. Don't get excessively creative. And I guess we should recognize that, I mean, McMillian to some degree is a product of a few years ago. I feel like our listening audience has become more sophisticated, understands the TCPA and compliance. So you wouldn't necessarily see that sort of thing happening these days. But there's a lot of other traps for the unwary that we'll talk about, I know, later on. But Leslie, I don't want to dodge your question. Why don't we have an answer to the meaning of the phrase ATDS? Well, it depends on how you look at the statute. If you look at the statute, and as courts for 20 years believed until 2011, that this statute is clear, it is narrow, it is properly drafted by Congress to avoid First Amendment issues, and it says nothing more than that you cannot use a dialer that has the capacity, right, the actual right now today configured capacity as we sit here talking to dial randomly or sequentially, then you're not using an ATDS. That's what the statute says. That's how it was interpreted by the FCC back in 1992. That's how every court to look at the issue until 2011 interpreted the statute. But as we all know, in 2003, the FCC imbued TCPA world with a whole bunch of doubt and uncertainty when it went ahead and expanded the definition, took it upon itself to cover predictive dialers. And the FCC really kind of out of whole cloth created new functionalities that trigger ATDS treatment that weren't in the statute to begin with. And these functionalities were the ability to dial without human intervention, using a predictive algorithm, and to dial thousands of numbers at a time. And when you kind of look at that package of functionalities, you're going to sweep in a whole lot of additional modern dialing technology, a whole lot of additional kinds of dialers and apparatus that weren't covered by the original statutory definition. From 2003 on through 2015, we lived in this very strange world of, well, the statute says one thing, but the FCC says something else, and what the FCC said was quite counterintuitive, so it took years for the courts to kind of come around to understand that they had to apply, probably, the FCC's interpretation under something called the Hobbs Act, which may or may not even matter these days. That's another element of uncertainty, but park that. So then we get to 2015, of course, and the FCC issues its monumental, crazy, expansive omnibus ruling, in which it takes its earlier 2003 ruling and it expands it even further. And now essentially anything that's a software-enabled dialing device qualifies as an ATDS. And that was the highest level of TCPA expansionism here in this country, with the Wheeler administration expanding matters as far as possible. Of course, the D.C. Circuit Court of Appeal and the ACA International, where have I heard that name before, opinion turned around and said, FCC, you've overexpanded the statute and you can't do what you've done. That seemed momentarily to be kind of the elixir that we needed to make certainty come back to the TCPA. It seemed that we were going to go back to the statutory definition. And then in September of 2018, of course, the Ninth Circuit goes rogue, reads the statute for itself and says, you know what, the statute's ambiguous. And even though we already passed on the statutory definition back in 2009 and found that you had to use a random or sequential number generator to qualify as an ATDS, now that we've looked at it again, post the ACA opinion, post the expansion in 2015 by the FCC, we're going to look at this with new eyes, and we are going to say that the statute doesn't actually require what it appears to require, and these words, random or sequential number generation, don't really have any meaning as applied in this statute. So really, all you have to have is the ability to store numbers and to dial them. And that my friend Leslie, is kind of where we stand today with 3 lines of cases. One of the lines of cases is dying out, and it may actually be dead. In fact, I called it dead just today in an article on TCPA World. That line of cases is the line that's still following the 03 and 08 predictive dialer rulings. The vast, vast majority of cases, maybe all cases now, hold those rulings were set aside by the D.C. Circuit Court of Appeal, which leaves us with only 2 options now. Option 1 is the statutory definition, which is becoming, I think, clearly now the majority position. It was the original position, and now it is the majority position. And the Marks approach, which is the expansive definition that reads out random or sequential number generation.
So maybe one thing that would be practical guidance, and by the way, listeners, there is a great scorecard that you can take a look at that is on TCPA World that sort of shows how the cases shake out and shows by circuit. So I guess you can figure out where I'm going to go next. If I am doing business predominantly in California, I might think that a court interpreting a TCPA claim is going to fashion its own interpretation rather than Hobbs Act type view where they would be waiting for the FCC to act. And then we saw this week there's a court in Tampa that took a position that no, the statute is plain, you need this random or sequential. The statute by its own wording was never meant to cover every possible type of computer-assisted telephony. What is the practical advice you would have for an agency that trying to figure out what calls it should route through campaigns, through things that could be seen as $1 versus other choices?
Well, it's simple. If you have any doubt as to whether or not your equipment is an auto dialer, treat it as if it's an auto dialer. Don't make calls on any equipment that might look, smell, feel like a dialer unless you have express consent. Now, we can take a snapshot today, right now, of the law as it stands, and we can say, hey, look, if you're not calling people in California, Oregon, Nevada, Washington, Arizona, and Hawaii, the Ninth Circuit footprint, you're probably going to be okay because most of the other district courts are going to be applying the statutory definition, but the law is dynamic. It's not a snapshot environment. The Seventh Circuit right now, as we speak, in fact, is holding oral argument in the Gattlehawk case, which is a major ATDS-laden decision that we're likely going to find out if the Seventh Circuit is going to apply the Marks approach or the statutory approach. And down in the 11th Circuit, there's a case on appeal right now looking at the same issue. So the final word on the definition of ATDS is not yet in, and there's no way to know for sure whether or not a call to any particular consumer in any particular jurisdiction is going to fall under any of these different approaches, which, parenthetically, is why the TCPA is void for vagueness and violates the Constitution as an unlawful restriction on free speech. But we'll leave that alone entirely for the moment.
Yeah,
but
I'm not going to let you take the rabbit into that warren, but I do want to sprinkle a little artificial voice seasoning here and ask you, okay, so let's say that you are satisfied that your technology, or as satisfied as you could be, maybe isn't an ATDS. What happens when you sprinkle a little artificial voice seasoning on your communications campaigns?
I'm so glad you asked that. People get very confused and they think, well, if I'm not using an auto dialer, then I can't be liable if I'm using a pre-recorded voice. And that's absolutely not true. Pre-recorded voice and artificial voice liability is completely separate and apart from ATDS calls. So if you are using any element of a pre-recorded element to your live calls, you are at risk. Now, that doesn't mean that you violated the statute. Now, here's the issue. There's another place where the TCPA is extremely vague. It is unclear whether or not using a pre-recorded voice such as this call may be recorded for quality assurance at the outset of an otherwise live call is going to trigger the TCPA's pre-recorded call requirements. There was a recent case where an outbound call by a debt servicer, it turns out, was made by a predictive dialer, which was not going to be treated as an ATDS in that case. However, there was a message used as part of the dialer's wait queue that said, please hold for an important message. The court found that that please hold message was a pre-recorded call within the meaning of the TCPA. Now that holding, in my opinion, is highly suspect. The legislative history, really all of the FCC's guidance on the subject suggests that a call has to be wholly pre-recorded in order to trip the TCPA's restrictions on pre-recorded calls. And there's a very important petition to the FCC right now filed by a company called Yodel, which will hopefully clarify the law. But for now, coming back to practical advice, if you are not using pre-recorded voice calls, don't use them. If you are using them, understand that you have to have prior express consent for those calls, and that includes IVF calls. And so again, if you're trying to use a pre-recorded message such as, this call might be recorded, it's far better to just have that agent speak those words in today's environment until we have real clarity that those sorts of piecemeal pre-recorded elements in a live call don't trip the statute.
Okay, well, don't leave that rabbit warren yet. Does it make a difference then? Because many agencies are using or considering using self-service IVR type technologies so that people can call in 24/7 and have unintended messaging or maybe even artificial intelligence or a bot walk them through payment options. So does it matter if the call is outbound versus the call is inbound?
Yes, it absolutely matters. Inbound IVR is fine. You can use it all you want. Now, there's an interesting kind of AI involved, and the consumer thinks it's a person, but we'll park that. From a TCPA perspective, inbound calls are not going to trigger TCPA liability. Now, outbound calls using IVR will definitely bring you within the scope of the statute, and I'll just say parenthetically, IVR calls are very dangerous for a number of reasons, especially where you've got, first of all, press 1 or press 2 campaigns to gather consent, never do that. But even when you know who you're trying to reach and you're using an IVR and you, for instance, are using a waterfall that includes press 2 if this isn't the so-and-so, the debtor that you're trying to reach, understand that that's going to create data elements that might enable class litigation in the future. So IVR is dangerous stuff. That's not to say don't use it, but just understand if you are using it, you definitely have to have consent. And even with consent, you're introducing an element of danger to your institution.
Okay, so don't go anywhere yet from this rabbit warren. I'm still stuck on a few points. So last week I had the opportunity to go to a state regulator conference, and not minutes after I checked in, I received a text message on my wireless phone from the hotel saying, "Hey, welcome. So glad to have you at the annual Conference of State Regulators. Press 1 if you'd like to opt in to get text messages about things going on in the hotel or nearby." Now, do text messages get the same treatment as voice communication for purposes of the conversation we're having?
So text messages are a really interesting little animal because, of course, the TCPA doesn't mention text messages. But text messages are treated as a regular voice call, not as a pre-recorded call, which is interesting because you'd think if a text is a call, it would probably be more of the pre-recorded variety. But there's a good amount of case law that says a text is not a pre-recorded call. What a text is essentially a voice call subject to the same requirements that a text made using an automatic telephone dialing system is going to require express consent. Now, the phenomenon you just described, Leslie, is interesting, and it likely has more to do with the durability and scope of the consent that you provided or were presumed to have provided when you signed up for this conference than the fact that you're using a text message medium. Specifically, anytime, of course, you provide your phone number to really anybody without contrary instruction, the FCC's guidance suggests and the court law demonstrates that you are presumed to have given express consent to receive informational messages on your cell phone, and that includes through the use of an ATDS. So it sounds to me that's probably what happened there, Leslie. Maybe you should read the fine print.
Sounds good. Well, next time I'll give you guys a call when I'm checking into a hotel and they ask for my cell number when the room's not ready.
Don't give it to me.
Sounds like a plan. Let's talk about some of these other technologies. You'll be joining ACA for a second year in a row at Fall Forum, and I know that over time we have begun to see more and more vendors that are trying to cater to the communication preferences of millennials. if you were desiring to take advantage of some of the technologies as a debt collector that would allow you, for example, to text a millennial to say, hey, just a quick reminder that your payment is due, what would be some compliance considerations that people should bring up with prospective vendors or should bake into any sort of program where they would be taking advantage of some of these payment reminder technologies that send text to consumers?
Well, before I answer that, let me just say we've been catering to millennials much too much lately, and I think that's really kind of driving some of the problems in our society. I'm kidding, sort of. I don't know if I am or not. So to get to the point, look, anytime you're engaging in a text campaign, and my friend Archduke, Daniel, feel free to jump in here, you need to have the belt and suspenders on, because unlike a voice call, which may never be answered and may disappear into the ether, and if the tree falls in the forest, did it really even fall if no one heard it? A text message is going to leave a record, right? There's going to be a little smear on this phone, and it's going to have, chances are pretty good, it's going to have your name and your phone number, and there's that text. And if they want to sue, well, that's going to be pretty affirmative evidence that you're the one that sent that text, and that text was, in fact, sent. You got to make sure you've got the requisite level of consent, and of course, you should never assume that whatever technology you're using to send this text is going to be sufficiently manual. Because although I did say you have to use an ATDS in the text message context, just because it's a text doesn't mean you're automatically liable. As you can imagine, there's not too many folks out there that are manually sending texts. And although the statutory requirements of random and sequential number generation are still there in this context, courts have been generally applying a lower standard of ATDS, both allegations, pleading, and proof in the text message context. So text messages are more dangerous, I would say, than voice calls for all of those reasons. So you want to make sure that you've got fully opted-in consent, just like you would for a cell phone call, but you want to make sure that text is actually mentioned, right? Text, SMS. You want to make sure that your disclosures say words to the effect of, hey, data charges may apply. You may be charged for these text messages. The hallmark really in the debt collection space, as in any other space, is transparency, right? Gone are the days, if they ever existed, that you could just kind of dupe a consumer into signing something and take advantage of it. Those days are gone. I mean, the courts are
right.
way on top of that stuff, and the plaintiff's bar is way too sophisticated. You're not going to get away with it. Don't try. It's not worth it. You're going to get a lot of people opting in anyway, even with plain as day transparent consent, because to your point, Leslie, the millennials do want to communicate this way. So don't hide it. Just tell them, here's what's going to happen. Provide your consent. You're going to get these messages, and you're going to be way, way better off. People get into trouble when they try to play cute or they try to play sneaky, and again, these days it just doesn't fly.
Eric and I have to listen to a lot of debt collection related call recordings kind of throughout the course of representing banks, creditors, and debt collectors in TCPA cases, and we're starting to hear in several recordings, can you just text me? Can you just text me? That's really becoming the preferred means of communication. So if you give people that option, I think you would be surprised at the rate of response. Especially millennials will prefer receiving a text, even if it's a payment text, than receiving a phone call. You can text while doing other activities. You can text while being on a conference call at work. You can text while driving. Yeah, not in Georgia, but maybe in some states.
But Siri helps. Siri helps with that. So
right,
Daniel,
yeah.
Let's stick with this for a minute. So let's say in one of these debt collection calls that you've listened to, customer says, you know what, I'm driving. I don't text while I drive, wink, wink, but if you wouldn't mind texting me a link so I could go online and pay. The compliance advice here, Daniel. So if you have a recorded line, you've captured the consumer's consent, the consumer gives you consent and you get the number, and then you send this text message, do you need to give the customer the right to opt out right away? Like, what if by the time they get where they're driving, they change their mind? Or what would be the compliance features once you send this text, assuming you got the consent on a recorded line and you got the number on a recorded line?
We always recommend giving the consumer the ability to opt out. The easiest way to do that is, as I believe you're alluding to, include a message that says something to the effect of, if you wish to no longer receive text messages from us, text STOP to opt out. because that gives a clear instruction to the consumer on what they can do to opt out. And it gives you a defense if the consumer responds and says, well, I don't really want to receive text like this anymore, something wishy-washy like that your text platform is never going to pick up or recognize as an opt-out. That way you have a defense in court to say, look, we provided a reasonable means for the consumer to opt out. It says right on the text we sent, they could simply press stop. They elected not to do so. Therefore, it was an unreasonable and ineffective means of revoking consent. So for that reason, we do recommend including a stop notification even after you've captured all the proper consent to send the text.
Okay, great. So now you keep saying a word, Daniel, and I want to stick with this subject for a while. There is a case that we all have sort of looked to as being a great bright line. And so let's imagine in the magical world of TCPA world that the debt collectors who are listening to this podcast have an opportunity to make a request or to provide some feedback to their creditor clients about this magical consent that seems to prevent you from the evils that come from violating the TCPA. So this case that I'm thinking of is sometimes affectionately referred to as the Good Reyes case, or Reyes versus Lincoln Automotive. And so I'm wondering about that case and its progeny. What lessons or what advice would you give to debt collectors who are able to provide some influence to creditors on this magical consent and what it should look like and what it should contain?
So the Reyes case, Good Reyes, which came out of the Second Circuit, as opposed to formerly bad Reyes, now less bad Reyes out of the Southern District of Florida, held that if you have contractual consent, cannot be revoked, because it essentially would amount to a unilateral revocation or unilateral modification of a bilateral contract, which is completely antithetical to 500 years of contract law. Really, the lesson to creditors would be, don't give individuals a contractual right to revoke consent in light of Reyes. Now, not every court in the country follows Reyes. Some courts out of the Sixth Circuit have followed Reyes, some haven't. There's a split within the 11th Circuit as well. Some courts have followed it, some courts haven't. So it's still dangerous to ignore a consent outside of the Second Circuit, and even after Reyes, but there's no reason not to take advantage of its holding when you're drafting contracts, with the understanding that as far as downstream compliance, it's still a best practice to honor a revocation.
And let me jump in here. I mean, because there's a fine line that should be understood. I think everybody in, first party, third party, and, creditors, everybody should be attempting to obtain written contractual consent these days. Now, certainly, maybe some third-party servicers just aren't going to have that ability, and you're going to have to kind of live with what you've got. I get it, but that should be the goal, is to get that written contractual consent. Now, the issue is, do you also offer a contractual revocation paradigm? And I will say, if you have the ability to operationalize across your enterprise, a one-stop shop for revocation, you should do that. It's going to make your life so much easier than trying to, for instance, train each individual agent to properly honor a revocation if you have in your contract a requirement that they, meaning the consumer, do something reasonable, not march down to the post office in Indianapolis and hand in a handwritten letter revoking consent. But, a dedicated phone number, 800 number, fax line, email box, where the revocations go to that location, and that is how the revocation is going to be valid. And although Daniel's right that outside of the Second Circuit, there's a pretty big split of authority as to whether or not contractual consent provisions are binding and irrevocable, the case law is pretty favorable and, frankly, pretty consistent that a revocation clause that includes a clear and reasonable revocation paradigm is going to be enforceable. And that's outside of the Second Circuit. You're pretty well served using those. That's something to think about.
So let me take you in one more direction before we wrap things up with any practical advice you want to give as sort of a recap. And I would like to talk about this business of dropping messages without making a wireless telephone number ring. I think for a long time, it was thought that there were not TCPA implications, and a lot of the vendors in the marketplace indicated that the technologies that they used didn't actually ring people's telephones. The question is I think we've had some surprises, maybe half a dozen or so cases where, in fact, the courts have found that the TCPA applies. How do we navigate that?
Well, it's tricky. So let me start by saying that I was one of the people that ringless voicemail providers first started saying, hey, look, voicemail is a Title III information service, not a Title II telecommunications service under the Telecommunications Act. I said, and then they said, so therefore the TCPA does not apply. And I said, what? That makes no sense. The TCPA is a living, breathing animal, true, within the Telecommunications Act, but that contains its own provision. And it cares not a whit whether or not the communication paradigm is an information service or a telecommunications service under what title of the Telecommunications Act. If you don't believe me, just remember that text messages are information services, and text messages are plainly calls under the TCPA. So when you're talking about voicemail, the whole argument that was advanced for a long time that voicemail is an information service, that just never made sense. And unsurprisingly, every court to consider that issue said, no, that argument fails. That's all you got, defendant, then we're going to find that your technology is a call under the TCPA. And so you're right, Leslie, there were a number of setbacks, and frankly, utilizing ringless voicemails without consent was an extremely dangerous thing to do. Now, if you've got consent and you're merely using ringless voicemail to supplement your outreach paradigms and outreach programs, then that's great. I mean, as a standalone solution, it's a great product. But the problem is that it was being shopped and utilized as not just as a solution, but as a buffer to TCPA liability. And that was dangerous stuff. But Daniel, there's been a change recently, maybe a silver lining here. Do you want to break that down?
Sure. So there's a new argument raised in the Saunders v. Dyke O'Neill case, the case that kind of originally set the unfortunate precedent that this technology is subject to the TCPA, where defendants making the argument that, sure, voicemail can be subject to the TCPA, but ringless voicemail is not actually a call to a cell phone, because in reality it's a call to a business landline and connects to the carrier server. It does not actually travel through the cellular telephony network to the end user cell phone, because it doesn't travel through that network and result in a call to a cell phone. It's a landline call, and therefore not subject to the provisions of the TCPA that are reliant upon a call being placed to a cell phone. Now, there are other provisions of the TCPA that apply to calls to landlines that could potentially be implicated, but if this argument succeeds, and we do believe it's the best argument against TCPA liability for ringless voicemail, it could really be a game changer for this space.
Well, it's a game changer, and just to complete the thought, it's a game changer for debt collectors, because debt collectors are informational callers, and informational pre-recorded calls to landlines are exempt from the TCPA. So you don't have to have consent. So if, and this is a mighty big if, but if the courts adopt the evidence that was submitted now by David King, the creator of the VOAPs, and that's, this is one specific ringless voicemail solution. That doesn't mean that they all operate this way. But the VOAPs direct drop solution, David King explained that when these calls are being connected, they are going to a business class landline numbers. They are not going to cell phones, or numbers, that is to say, numbers that are assigned to wireless services, which is the watchword in the TCPA. So again, if you're a debt collector, you should be watching this very carefully, because if ringless voicemails are not found to be calls to wireless numbers, wow, you're in business. I mean, that becomes a great technology that can be utilized. Now, in fairness, it's going to be years before there's any clarity on that issue. Even if the first couple cases break in your favor, don't all rush for the exits, because believe me, it could change. But this is definitely something to keep an eye on.
That brings me to my last subject, and that is shake and stir. So let's say that I am a company and I am making calls, and then, heaven forbid, I get a TCPA lawsuit in this day of call blocking and call labeling. So what, if anything, are the implications of shake and stir, and When in your crystal ball do you think the FCC might issue some regulations that would offer clarity in this realm?
So you got a couple of different issues there, and it's important to recognize that the FCC's recent default call blocking rules are an absolute paradigm shift. They allow the carriers to block your calls using quote-unquote reasonable analytics to decide whether or not your call as a debt collector is going to be wanted by that consumer. And man, oh man, is there a big split in terms of what the analytics show, right? You look at some analytics performed, for instance, by a company called Hiya, and it shows that only 2% essentially of unwanted calls are debt collection calls. And then you look at the UMail robocall index and the strange inferences that are being drawn by certain consumer agencies out there that essentially all the worst robocallers in the country are debt collectors. There's a real big split. It's going to be very, very interesting as these carriers start rolling out their algorithms to start blocking calls. What side of the fence are the debt collection calls going to fall on? On the one hand, we know that these are extremely important consumer-friendly communications, but on the other hand, we know that the plaintiffs' bar and the NCLC and other special interest groups really like keeping scorn on these calls. Which way the algorithms yield, it really could be detrimental to the industry. Anyone not paying attention to these developments, not commenting to the FCC, not contacting their friends in Congress and or their friends at Squire Patton Boggs, you really should be, because this is a big deal. To answer the question about whether or not you're going to know, right, what the carriers are doing, and to a lesser but still important degree what the app manufacturers are doing, there was some recent determinations by a committee within the FCC that the FCC should issue formal guidance requiring the carriers to notify callers if their calls are being blocked. Those requirements have not yet rolled out, but we do expect that that'll be out here in the next 6 months or so. So there is going to be some form of notification, and there is going to be some form of a redress mechanism that's going to exist at the carrier level, where callers who feel that their calls are being blocked inappropriately will be able to stand up and say, hey, not only is this a true call under the shake and stir framework, which we'll talk about in a second, but this is a wanted call, and your reasonable analytics should not be removing this wanted call from delivery. Now, today there are vendors, even as we sit here speaking. I can think of my buddy Rebecca Johnson and her great company, and I know a lot of other vendors out there that are trying to keep callers informed, even now, even without these rules in place, as to how their phone calls are being perceived by the carriers and by others. I can help provide guidance and help soften the blow of some of these pretty draconian rules that the FCC has put into place, frankly. But setting all of that aside and circling all the way back to shake and stir, remember, shake and stir is just an authentication framework that the carrier networks are trying to implement amongst themselves. It's going to turn on whether or not your outbound business carrier, let's say you're using Verizon Business Communications, have they, the carrier, adopted the shake and stir framework. And once they all do adopt the shake and stir framework, which is a way to authenticate the call is actually coming from the person who is trying to make the phone call and that essentially the number is not spoofed, then once everyone has implemented that framework, which should be happening right now as we speak and will be complete soon, then part of the default call blocking rules that the carriers should be utilizing is blocking connection of any non-authenticated calls. But since that framework is not yet fully implemented, carriers are not yet blocking calls using that framework. But we will start seeing that happen in about a year. But there's not much that a collector can do to make sure that their calls are meeting that framework, other than essentially, I mean, I hate to say it, but using one of the big carriers as their outbound business solution, business partner for outbound calls.
All right, so I'm going to recap where you've taken us so far, and it has been a wonderful substantive adventure in this podcast. We started out by talking about the importance of not auto-dialing skip trace numbers. I think that one very painful decision made it very clear that while it is great to try to use means of communication that consumers prefer, it is best to find out whether consumers prefer particular methods of communication from them directly rather than from friends, family members, or other third-party sources. We then kind of talked about all the confusion over what may or may not be an ATDS. So if you are using any sort of automated dialing, whether it is computer-assisted, predictive, make up your own name for it, one thing that is clear is that knowing your technology and knowing the ways that you are using artificial or pre-recorded voice on outbound calls is something that merits a little bit more attention, including if people are getting a funny artificial voice message while they are in your wait queue, or if they are just getting some compliance disclosures that perhaps are accurate if pre-recorded, but perhaps could be found by a court to be violating the Telephone Consumer Protection Act. We then talked about how texts are treated more as voice calls, although there may be slightly more liberal judicial interpretations. And then we seemed to turn over to some regulatory issues and whether we think that the FCC's choice to take the robocall ramp and give some free rein to carriers to start blocking calls based on some algorithms or formulas is a good idea. I know we didn't talk about whether there are any reliable databases to verify the telephone number a consumer's given you is or isn't the right place. Are there any other topics, and maybe each of you want to take a couple of minutes to ask yourself the question you wish I'd asked you in this podcast but didn't? And Daniel, why don't we start with you?
I think we covered pretty much everything. The big takeaway is while the law is still this much in flux, this much uncertain about everything we discussed, what is an ATDS, whether ringless voicemails are covered by the TCPA, how much separation there has to be between two systems so that you can't essentially borrow the functionality of one to make a manual system in ATDS. Until all of that is straightened out, you need to take a very cautious approach and conservative approach to compliance. So even though we push cutting edge theories in litigation, that's not what you want to do from a compliance standpoint.
And that's a great point. And I will say there are lots of questions I wish you had asked me about cutting-edge esoteric issues, constitutional issues, the definition of the word system, what it means when you're a new star right now, following a couple of decisions just came out, the Hobbs Act, PDR resources, platform liability, vicarious liability, the liability of individual officers for TCPA actions by corporations. So many incredibly diverse, fast-moving, esoteric issues out there. But if you are looking for nuts and bolts guidance, you're not going to get anything better than what Daniel just said. Be conservative. And yeah, you get tagged with a class action, folks like us will help you. We'll come up with everything there is under the sun to make sure you get the best defense possible, but don't rely on any of that. You use common sense and think about two basic principles. One, if consumers want the messages and are receiving the messages in the way that they have asked to receive them, then you're going to be okay. And two, if you're reaching customers that are happy about your messages and or receiving the messages according to their contact preferences, you're probably going to have better collection rates and realization rates as well. So, really sometimes the law and best practices just kind of combine. Don't be overly regressive out there, and you can get past even the struggles of complying with the TCPA.
Well, thank you both very much, and thank you to your law firm for the generous sharing of your time. I know that this will air in advance of Fall Forum, and hopefully people will have a month then to think of some great questions to bring to Chicago to ask you when you are kind enough to share more of your time. Thank you to the Members Attorney Program Committee for allowing us to reach out to industry experts like Daniel and Eric to put together this podcast for you so that you can get some cutting-edge information. Probably by the time this airs, who knows what cases will have been decided. So take a look at TCPA World and see if you want to keep up with some of the things that may have occurred in between the time we record this and the time we see you all in Chicago in November. So thank you very much and have a great day.
Thank you, Leslie, for that insightful interview on TCPA developments. If you want to hear more about this topic, Eric will be presenting at ACA's Fall Forum in Chicago on November 6th to 8th. And if you enjoyed this episode, you can subscribe to ACA Cast in iTunes or wherever you download your podcasts so you'll never miss a show. While you're at it, if you find value in this show, we appreciate a ratings on iTunes or simply tell a coworker or friend about the show. Thank you, and we'll see you next time on ACA Cast.